tonight's meeting. Okay, welcome to the September 23rd, 2024 meeting of the Standish Zoning Board of Appeals. This meeting will now come to order. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all the exhibits that are being offered. Please notify the chairperson, which is myself, if you are unable to see or hear or need an accommodation. The board works from a prepared agenda and will be considering tonight's items in the following order. We have one item under new business, an application for an administrative appeal. The applicant is Jeff Tracy. Land use for installation of a seasonal structure, a dock, map 46 lot, which is referred to as the Common, and it's in land use district rural with shore land overlay. For each case, the applicant will be asked to proceed first and then be available to answer questions from the board. After the applicant has spoken, all other interested parties may make their presentations and then be questioned by the board. After all interested parties have spoken, each side will be given an opportunity for a brief rebuttal if necessary. Once the public comment session is closed, the board will deliberate and decide the matter. This meeting is being recorded, and it is very difficult to hear what is being said when multiple people speak at the same time or do not speak into the microphone. Please refrain from interrupting other speakers. Questions should be addressed through the chairperson.
Why do you keep hitting the mic?
Oh, sorry. Because it's not going over the speaker. Usually you hit it.
You good?
Good.
All right. We ask that each person offering testimony come forward to the microphone at the podium and begin by giving his or her name and address. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinance or ordinances. As a reminder, for an administrative appeal, the board acts by vote of the majority of the members present and voting. There are 5 members here this evening that are present and will presumably be voting. As such, the applicant will need to acquire at least 3 favorable votes for their application to be successful. Following a decision on an application or appeal, the board will prepare a written decision indicating its findings of facts and conclusions of law that will be mailed to the applicant within 7 days of the board's vote. If your application or appeal is granted, you must obtain a building permit from the code enforcement officer. If anyone wishes to appeal the board's decision, you must do so to Superior Court within 45 days. Are there any questions about what I've just read? Great. All right. So, new business, an application for administrative appeal. Again, the applicant is Jeff Tracy. Land use, installation, and use of a seasonal structure, a dock. Structure to be placed on a common lot, property owners with deeded access to said lot for the purpose of bathing, boating, and mooring boats. Before we ask Mr. Tracy to come to the podium and speak, does any board members have a conflict of interest with said applicant?
No.
Oh. Hearing none, we can proceed. The public session is now open, and I'll ask Mr. Tracy to please step to the podium and speak to his application for an administrative appeal.
Hi, my name is Jeff Tracy, 10 Great Bay Road, Standish. We're asking for an appeal for the denial on the dock that we put in without a permit, which we had to see after the fact. We have this, as a neighborhood among us, the permit is just not for me. There were 3 other people on the permit. Since then, with the exception of one of the people who has deeded access, have all agreed that our intent to place one dock at the common frontage, which is approximately 142 feet, is what we're appealing. Based on, I received a letter this morning actually from the attorney, and have questions regarding that, but as it states in all of our deeds, we do have the access or the easement granted to for boating, mooring, and bathing. We believe that a dock is essential to each of those. By definition, a dock can be used as a point of mooring, number one. Number two, under the Maine State Title 33, Section 459. The definition of the dock, as it states here, means a platform used for access to the water body or to secure, protect, and provide access to a boat or ship. Platform may extend from the shore over the water body and may be a floating platform attached to a mooring. Now, this is under easements, Section 459, which states easements and right-of-ways, installation of docks, which I feel relates to us directly. Easement of the right-of-way, the definition means the right of the person to pass over land of another person. I think there's some dispute as to how the common is owned. There is no deed for that. There is no title. There is no way to search back to find the developer who initiated the development. However, based on the fact that it's called the common and that we all have access to that, have been taxed for that on a proportion of the area of that site per lot in the subdivision, we feel that we have absolute right to go down there for those purposes. The only difference stated here is under Section 459, number 2, it says easements or right-of-ways established on or after January 18th. It says the owner of the easement or right-of-way leading to or touching upon the body of water does not have the right by implication to construct a dock on the easement or right-of-way or use the easement or right-of-way to facilitate the construction on a dock on the water body if the easement or right-of-way is originally established in a written instrument executed on or after January 1st, 2018. Our subdivision was established back in 1933. Under that same heading, B, the instrument granting or reserving the easement or right-of-way does not expressly include the right to construct a dock on the easement or right-of-way or the right to use the easement or right-of-way to facilitate the construction of the dock on the water body. That's under the same heading as after January 2018. That neither of those apply to us, where it is not, although it is not explicit in our deeds that we have the right to install a dock, we were before that stipulation, and by means of boating, bathing, and mooring boats, our dock is what we consider to be essential to provide access. So if there's any questions, I did look at the letter that I received from Mr. Walton, I assume. He did cite Rancourt versus the town of Glenbourne as a reason as to reason the law held that the right-of-way ingress and egress to the lake. Well, our deeds not only provide for the ingress and egress, it provides for the purposes of boating, mooring, and bathing, which we consider swimming these days. So I guess I would just like to have clarification on that and answer any questions you guys may have.
Mr. Attorney, do you want us to start by responding to that?
I'm happy to.
Sure.
So I think the more important point, rather than the Rancourt versus Glenbourne case, is the Tomasino versus Town of Casco case, which holds that a municipal board or official doesn't have authority or jurisdiction to resolve disputes as to the scope of an easement, meaning, what a party's rights are under an easement if they're in dispute. And that's, it may well be that a court would find that this easement does include the right to install a dock, but I think it's at best ambiguous, and because there's a dispute over it, this board and the CEO just don't have authority without something clearer in the deeds or a court adjudication.
I think I would only respond to that by the the title 33 of the state law, which I stated, which defines the dock as a platform for the use of securing a boat. Now, if our deed provides for boating, bathing, and mooring, a dock is pretty essential to all three of those, or at least two of them. So the state law would tend to kind of be in unison with what our deeds say. As again, it says water body, or to secure, protect, and provide access to a boat. That's, to me, that's pretty simple. That's not ambiguous at all, so.
So I have a kind of a follow-up question that involves that, and since you're an attorney, perhaps you can answer this for me, or
Absolutely.
provide an opinion.
And I'm happy to ping pong back and forth.
Sure.
I was just waiting. Yeah.
So on that sort of note, looking at the Title 33 of the Maine Revised Statutes of Section 459, I find it interesting that it's specific to the installation of docks, easements and rights of ways, installation of docks. It's silent in terms of defining a mooring, but its focus is on docks. And you suggest that Section 2, which focuses on the establishment of an easement or right-of-way after January 1st, 2018, doesn't apply to your particular situation because these deeds presumably were created back in 1933 or
It's the original subdivision.
original subdivision deeds, right? But then you go on to argue that subsection B doesn't refer to you folks or apply to you folks because it's tied to that date.
Correct.
However, it's interesting how the language of the statute, the main statute, speaks to the date in Section A, but doesn't speak to the date in Section B. And so I guess my question, and maybe this is a legal opinion, is can you view them separately, or is Section B specific to the date under that heading?
So if you want my opinion, I think it doesn't really matter. I think I'll put it this way. I think it's appropriate for the applicant to use the definition of docking contained in that section as support for his position that his easement includes docking, or includes the right to install a dock. I think it doesn't get you over the hurdle into you have a clear right to install the dock, precisely because you can engage in all of the activities described in those deeds without installing a dock. You can have, a mooring usually, I think there's a definition in the record that says mooring is most often used to describe attaching your boat to a mooring buoy in open water, which is certainly what I think of when I hear the word mooring. And that doesn't require the installation of a dock, and neither do bathing or boating. And so again, I think it's conceivable that this easement, as originally intended, might include the right to install a dock, but it's far from clear.
Other questions from the board for the applicant?
So if we don't actually have the jurisdiction to approve it, does that mean we have to deny it?
You're asking,
Yep.
You're asking me?
Yep.
I think it does. I don't think, it's up to the board. I obviously represent the CEO. I'm not advising the board directly. My opinion is that what's before the board right now is reviewing the CEO's decision, and the CEO found that the CEO denied the application because the applicant had failed to establish RTI, and I think the board has to approve that decision because there isn't sufficient, evidence in the record to show unequivocally that that the applicant does have RTI.
So then the next step is going to court to get an opinion on an interpretation on the easement?
I think that is the way the law works in this area, and I understand how frustrating that is for, in these kinds of situations, but that's my read of the way the courts have decided these cases.
If I could just interject on Mr. Cutler's observation that the easements and right-of-ways after this 2018 is a separate heading. So anything that falls under that is for that period of time after 2018, whereas it states that you can't imply the right to put a dock in after 2018. But with our language providing for boating, mooring, and back in 1933, mooring could, as is defined in many definitions, anytime a boat is attached to a dock, it's moored. We also have, I think in the permit, I also indicated that our dock would have mooring whips or mooring cleats to provide, to secure a boat to the dock. Again, that's how they're sold, as mooring whips and mooring docks. So I think from the standpoint of what our deed says, our interest, our easement falls in line with the definition of the dock. And regardless of, you know, I mean, you guys make your decision, and I'm glad to answer any more questions, but to me, it looks very straightforward.
You applied for the installation of a seasonal dock, right?
Correct.
Does that mean this is just brand new, or did one already exist?
It's an after-the-fact dock. We actually, several neighbors and I put a dock in, primarily to benefit Ms. Riccio, who does not have access, direct access like most of us do. And I think back probably when the common was established, a lot of it was probably linked to providing that access, because probably the 14 sites on the water, 12 of them have high banks. So you're looking at anywhere from 22 to 30 stairs to get down to the water. Stairs aren't a problem for any of us now, but at some point, having that access to be able to walk down into a level area to gain access to a boat would be beneficial. In fact, that's an excuse my mother gives me for not coming to visit at 83 years old. She won't go down my stairs. So.
Okay, so it sounds like a seasonal dock has been there.
We installed it without a permit, and then one of the neighbors objected to the dock being there, and that's what got this rolling as far as, unfortunately, most of us put our docks in and out and we don't think about permits, so we really didn't think about a permit, and I apologize for that, but, so we applied for an after-the-fact permit.
When was the dock initially put in there?
It was around Memorial Weekend.
So it's brand new. It's just this year.
Correct.
Yeah, it's a new installation this year. It's an old dock, but it's
And how many people in the community have access to the common?
there are 15 that have access. There's,
This deeded access to the
Correct.
common, 15? And
that doesn't include some of the back lots that primary owners have front lots, several have back lots. Some of those back lots, their parcels are indicated as having access as well.
And none of these individuals, including yourself, thought they should ask the town to put in the dock first? They should get a building permit?
Yeah, well, we should have taken a permit out, but we didn't at that point.
I got a question. Is there any evidence from a historical standpoint that there's ever been a dock there prior to this Memorial Day?
There was a bridge that connected, I don't know if you can look at the, if you have a copy of the tax map or the subdivision plan. It's called Hayden's Bog, which goes in behind there, but at one point, back in the day, there was a bridge there, which connected. I believe Sunningdale was the old camp, boys camp or whatever it was, and they had stables on our side, which was on the Piper's property, and then the caretaker's house was Perfilio's property, which is next to that. So at one point, there was a bridge that connected,
Over the bog, not into the lake?
not into the lake, no, over the bog was this structure.
Okay.
I have pictures of the dock if you want to see it. I don't know. if
I saw the plans in the request for the building permit. Prior to the dock going in this year, how many moorings were out there? How many boats were tied to moorings out there?
Well, most everybody who has a direct frontage has a mooring. There's one mooring that Ms. Riccio has out there at this point.
So only one mooring is being utilized.
Correct.
And has that been like that for many years, or?
No, I think it was just put in this year.
Mr. Chairman, can I ask a question to Mr.
You may.
Are those moorings docks, or are they mooring balls in the water?
It's a mooring ball, buoy, whatever. Yeah.
So, if I understand you correctly, that up until this year, or within the last 12 months, the use of the common for mooring purposes nobody was using it. They just happened to use it now.
Yeah, this is to benefit Ms. Riccio primarily, but we decided as a neighborhood to support her in trying to get this through. It gives her a place.
And you said that people in the subdivision have moorings on their frontage. They currently do.
Yeah, most do. Most have docks.
Did anybody think of offering a mooring to Ms. Riccio in front of their property, or the
She
butters?
comes out to our house quite often, but I think that, I mean, she's here, she can speak for herself, but I think she likes to have her own space, and that provides her with privacy and kind of not being,
Well, but you're suggesting privacy on a common space, common use space. I wouldn't suggest it's very private.
if you've seen it, you'd know that it's fairly private. You have to be going there to get there. But the dock can be used by anyone. We're not making exclusive, and we're not trying to put in multiple docks. It's just one spot, helps her store her kayak and have a place to keep it.
What does this area look like? Is it sandy, is it rocky, is it boggy?
It's wooded. Again, I have pictures of a pathway that leads down to it. It's a wooded area. There's a stream that leads out of the bog that kind of bisects the frontage, which again is about approximately, I think it's 142 feet on the plan.
Do a lot of people use this area?
We've used it in the past to go down and, mostly to go in and kayak into the bog, so it gets used. More so in the past few years. Like I said, there's a path that's constructed
Right.
for DEP rules.
And do you guys have meetings, or is there an association that is
There's no formal
associated?
association that, although it's possible we can go down that route.
Do people swim there?
Sure.
Right.
Oh, yeah.
Without the need of a dock?
There's a beachy area, correct.
There's a beach area, yeah.
But for anybody that's got into a kayak in shallow water, you know what that can be if you haven't got something to hold on to.
Other questions for the applicant from the board? No? Okay. Thank you, Jeff. Don't go too far. I'll invite others from the public to speak, either for or against this application
All right,
at this
thank you.
time? Thank you.
Hi, my name's Mike Brady, 26 Great Bay Road. I'm relatively new to Great Bay. Lived there for 3 years. It's actually my home. I'm a resident. It's not my summer home. Again, I got this letter from the attorney. It was sent to me through a text, so I didn't have a lot of time to look it over. But I actually had a couple questions. It seems to me the RTI came up a few times about the right title and interest. To my understanding, and Jeff told me, we have a separate line on our tax map for this property. So I guess the question is, what's the dispute about who owns it? I mean, the right is through our deed. We have 14 of us. Is it 14? 15? 15 of us have the right. Let me back up a little bit. I don't know if anyone's familiar with Great Bay Road. It's off of 114. So we go 3/4 of a mile down a dirt road, and 14 of the 15 properties are elevated properties. For instance, my property I set 37 feet above. I went back in the deeds. Mine says 1948. They say this was established in 1932. And to me, the common area was established for the simple fact that most of our homes, like I said, 14 of the 15, with the exception of Hawley, we live on the water. But back in 1932, they certainly didn't have the dock systems, stair systems, and all these things that we have nowadays. And it seems to me this is why the common area was provided, because you walk down, it's low, it's level, it's flat, it's a beachy area. The only person that has the low-level flat area is actually the complainant who abuts the common area. So I just wanted to give you some people might be familiar with Great Bay Road, some might not. It's very quiet, it's very private. You know, as we say, when we see cars down there, they either belong there or you don't, because you just don't stumble on Great Bay Road. The question about the right, the RTI, the right title and interest, I guess I'd like a clarification on that. So I have a deed that says I can go to the common area, and it spells it out 4 feet wide down. As for the title, you know, as Jeff once said, he's been paying taxes on this property for 30 years, and then all of a sudden we're hearing, well, we don't know who owns it. In my understanding, I have a limited real estate development, but even nowadays, when you put developments in, you have to put common areas in. And it seems like not only they put a common area in here, they conveyed it to all the owners, which is why we are 1/15 owners of this property, which is why we pay taxes on it. We have 14 of the 15 properties who we actually got together today for an email who support this. We would like a dock. The reason for the dock is Ms. Rico, she has the back lot. So this common area is actually her waterfront. Now, I guess, Mr. Cutler, to your point, you said, can somebody borrow, do you have an extra mooring or something like that? In Great Bay, yeah, we would probably do that, but these are still all private properties. I have a large docking system. I got that permit from probably the week I bought the property, and I was granted that permit. But at some point, when this development went in, none of these properties had permits for docks. So when did this all start to change? How come the people private on the waterfront, and this is a question, why were we permitted docks in the common area where I'm a 1/15 owner and 14/15 of the people would like a dock? Why aren't we permitted to have a dock there from what the law says? That's why I'm a little confused on the RTI. I've got the right, my deed says so. I got the title because I pay taxes on it, and the interest probably goes back toward the fact that I have a deed that says I have the right to go there. So I guess I was a little confused by the letter. What's the confusion about the ownership? Anybody, I guess?
I'm happy to respond unless the board. So I think the RTI is not some RTI, it's the right title or interest to install a dock.
Okay.
And that is really the important, you do have, RTI to go and, to
Yeah,
use it
yeah.
as you, but in order to establish RTI to build a structure that requires town permission, the town permission can't be granted unless RTI to do that thing is established. And
But didn't we just establish that?
so that's why the dispute is really the crux of this. And actually, one way of kind of getting at your question is by finishing something that I was saying to Board Member Ramirez earlier, which was the way around this problem that you're facing. And one, it's, I'll be honest, a little unclear to me who owns this lot, this common lot. And if it's possible for you to establish that you do have title to it, whether that's, I guess I'm a little confused about what you're saying about the,
Well, I guess you answered some of my question. You said you're confused about who owns it. Why am I paying taxes on it?
Right.
I own it. I own 1/15 of it. I've been paying taxes for 3. Jeff's been paying for 30 years. A lot of these folks have been paying for 30 years. We're all paying taxes on this. And from my understanding, what Jeff told me, and I haven't seen this, so don't hold me to it, on our tax card, down the bottom, it's separate, that this portion, X amount of dollars, is for this common area. So, on one hand, if someone else owns it, the city's gonna owe Jeff and a lot of
Excuse
these
me,
folks a lot of money.
can I just
Go ahead.
hold right there?
Sure.
I'm going to remind folks that, all that sort of back talk, and it's disruptive, and sometimes it's hard for the audience that's watching this on TV. So if you have, either take it out in the hallway, or if you have questions or comments, you're free to come up to the podium after the person there has something to say. Sorry, go ahead.
No problem. I guess that's my question. Someone's gonna owe us a lot of money if this is not our property. And that would include the city.
So, Mr. Chairman,
JP,
the gentleman spoke about subdivisions of the common land. That's in cluster subdivisions, not in all subdivisions. So a cluster subdivision does have common or
Yeah.
green land or
That's
open land.
new modern things, right?
Yeah,
Yeah.
and they all pay everybody that is in that subdivision pays, that's part of their land, that's part of their taxes, but they cannot build on it, they cannot use it, they cannot put structures on it. So.
Yeah, I'm not
So now we were getting back to the point of why this was written in 2018, is because it was so, it's muddy
Right.
of exactly what can happen on these common lots with these right-of-ways.
Well, to give a little context, before I actually moved to Standish, I actually lived on Woods Cove, which you probably know. And there's a whole lot of things that get muddled with people, what they say, what they do, and what they believe and what they don't believe. But we're not asking to build a structure, we're asking for a seasonal dock like every other property, and thousands are on Sebago Lake. That's what we're asking for. We don't want to put a house. Jeff had pictures. I don't know if you provided a picture of the actual area and what we're actually talking about here. This dock is 8 by 8. I'm 6 foot, well, I'm probably 6'3" now. I'm getting old and shrinking. So you lay me down and spin me around. This is what we're talking about, 8 by 8. It's not a dock system like I have that's 40 feet out with an L and boat lifts and jet skis and things like that.
Mr. Chairman, so the current dock that's there is correct, but the one that was applied for is bigger with mooring whips and such, so it's not the same size. The dock that's there is one section, and the dock that was asked for is more than one section. So,
Is there a difference?
yes,
When-
because you have to, if you submit me a plan,
Yeah.
you have to, and you have 3 sections of dock, you can't put 5 sections on without reapplying for another permit.
Oh, yeah, okay, yeah, I
So
understand
the
that.
dock that was there, one was put in without a permit,
Right.
okay? And it's not what was asked for in the application.
Yeah, I understand that, but is there a difference whether if the dock, let's say you say, yeah, you can put a dock there, does it make a difference whether we say we want 2 sections or 3 sections, as long as
Well,
it's
I'm just
permitted
getting to the point
correctly?
of your pictures you have of the dock now isn't what was asked for in the permit. It's a
Yeah, I don't
smaller-
know.
It's a smaller dock section.
What's there now is there's one 4 by 10 foot section that leads from the shore to a 6 by 8. And when I applied for the permit, I asked for another 6 by 8 because the water, when it goes down, that kind of recedes from the dock. So that's, I figured if I'm going to put in for a permit, I'd put in for
Absolutely.
what we wanted.
Yep.
That's just a point of clarity, though, right?
Yeah, of the
It
picture.
doesn't matter what size dock, we'd still be
Okay,
here.
I guess that's what I was asking.
Yeah, so I'm not a tax attorney, but from what I gather is you all pay taxes on common area because you have an easement on that common area. And you have an easement for certain specific uses. So that's likely why you pay a portion of taxes on that. But to the attorney's point as well as to JP's, to construct something such as a seasonal dock, you need more than just an easement. You need to determine that your deed allows you to construct something on that property. That's the stumbling block.
So I have just a comment on that, and maybe JP can help me a little bit. So I have the good fortune of living down by Wards Cove Road, but I'm part of Sebago Lakeview Corporation. Are you familiar with my beach? It's deeded just like these people's deed reads. It was the Lincoln Hawk subdivision out on 114. Every one of us owns 1/30th of the beach. We have a dock. We swim, we play, we moor. It's kind of the same setup. What's the difference? What's
I
the
wasn't
difference?
here when they first
Right,
put your
but-
dock in, and I'm following the state law.
But, well, and I understand that, but what is the difference between their deed and my deed? My deed pretty much reads how their deed
We
reads.
don't have your deed in front of us.
We'd have
so I
to see
can't-
it.
Right.
can't
Yeah, we'd
comment
have
on
to
that.
actually look at it and compare to say, is it the same, or do you have more specific distinctions for use?
Well,
that
I
common
can
area.
tell you, I don't,
I don't
you
know,
know,
yeah.
so I'm just really confused as to why we're bringing into play if they own it or not. If it's part of their deed that they're allowed to use this common, I think it would be probably in their best interest to have a corporation set up like we do, where we vote and the majority rules, but I don't see a big difference between what they have and what I have, and we are able to enjoy a dock and the beachfront, and it can be very private, and I share it with 30 other residents.
Yeah, again, we need to make a determination based on these facts and what we see in this deed. And I can't speak to what you have in your, quote, similar circumstances,
Right.
unfortunately.
I feel as though they have the RTI from the little bit that I've heard here.
Well, and I think, and that's my main, and what I'm hearing here is there's some beliefs about the RTI and not. And my question just went back to the simple thing, we're paying taxes on, it. I understand how you answered that, but there's no ownership of this property, which means, what doesn't mean. I assumed originally, back in 1932, I can only go back to 48 because that's what I saw, that was the entire intent of this 15-lot subdivision, was to have the commons included and have a 1/115th ownership because of the nature of how our properties sit, especially back in 1948, where nobody, like I said that earlier, nobody would dream we'd have docking systems and steps and things like that the way they are. That's my big hang-up is the RTI. I'm hearing, well, we're not sure who owns it, but I'm like, well, a lot of people have been paying a lot of taxes on it for a lot of years on that. You know, I'm probably done here. Yeah, my big question, the question I had was, who owns the property? And I have to assume, as a guy that's been paying taxes in the town of Standish, and it says right on my line that, well, I'm at least 1/15th owner of this, since there are 15 deeded accesses to this property. It was nice meeting you all. This is the first time I've actually been here, and I'll probably see you again at some point. Thank you.
Thank you.
So my name is Charles Piper. My wife is Diane, who's also here. We are the owners of 36 Great Bay Boat Road, which encompasses on the subdivision plan from 1933. Lots 12 and lots 13. And yes, there are 15 people who share an easement. The subdivision was created in 1933. Our land is one of the lands that is down low, and we have a very nice beach. We don't have to walk down a big embankment. Of all the other properties, everyone who put their name on this has a beautiful dock. They have moorings out in front. Yes, they have some embankments to get down to their dock areas. So the background on this is that there was one back lot, only one, that was given a deed. And that back lot was owned, well, first of all, in terms of owners, Harold Hanold, who owned Hanold Company across the street here, was the owner of all this land. He bought it from the Hayden family in the early, actually late 20s. And one of the houses on that property was our next door neighbor. And they built a cart path to go across the bog and go over to where Camp Sunningdale is now. We've had absolutely no problems, and we've been very accommodating to our neighbors. One of the challenges has been that we are the only lot that is low to the lake. And a lot of people want to get between the neighborhoods, from the Chapman Way neighborhood, which is across the bog, and our neighborhood of Great Bay Road. So we've had a history of a large number of people having to get across. So our property has a private driveway to reach it. It's not part of Great Bay Road. If you look at the tax map, and it's actually included in this packet, you'll see that the Great Bay Road, which of course wasn't called that, actually ends at the division between lots 10 and 11. So in other words, right at the border of Mike Brady's property. And a private driveway goes down to our area. The right-of-way takes a sharp turn across our neighbor's lawn and then goes through woods that are very dense and thick. And when Holly Riccio bought this property, she had a disabled husband. And he was unable to easily reach the lake. And so they actually built a bridge, and they cleared a lot of land so that he was able to reach the lake. And we made a number of concessions, including letting Holly, and we put this in agreement, Holly and her husband, who had to go in a vehicle, to go down the private driveway in order to reach this property. You may have an attachment that we set there that shows the location of the right-of-way versus the private driveways. And the private driveways is a function of both our next-door neighbor, Anthony Perfilio, and our property. So I think to the point, I'd like to simply amplify on some points in the legal opinion that the town got. First, in terms of the applicant does not have sufficient right or title and interest. So when the property of 5 Great Bay went on the market, the Realtor actually showed pictures of these private driveways and showed pictures of our private beach to encourage people to buy this property. And that, to be honest, that was upsetting. So we did some research to understand what the easements allowed them to do. And the easements are generally interpreted to mean whatever the language is in that easement, that you have the right to bathe, boat, or moor a boat. And you do not have the right to overburden the easement by using the property for other means and activities. As far as the, so when this dock was going in, I said, did you get permission from the owners of this land? Because it's not owned by them. So we, unlike modern condo associations, we do not have 1/15 ownership of this land. It is a small parcel. There is a wetland, which is a protected wild bird habitat, which is adjacent to the lake, which is at the backside of this property. So the easements usually are interpreted to mean when the grantor of that easement says you can use my land for these purposes, you use that land as is. The other part that's important here is the issue of 15 different people who have these deeds. And we have background in terms of we've been there a long time, but a lot of the neighbors have enjoyed this area. It is an area of a protected wild bird habitat. The bog in past years has been a beautiful place. Jeff even mentioned, it's nice to take your kayak and go out there and kayak around the bog. A lot of kids go fishing back there. I fished a lot more back there when I was young. One of our neighbors recently commented to me. He said, all my kids loved to play in that area. It was a magical area. And now it's not so much so. We've tolerated a lot of things where people have used our property. A septic installer once came down and drained our tank, and that next winter, all kinds of ice fishermen were using our parking lot because it had easy access to the lake. And at the end of that season, they left an ice shack right on our property. Another time, a neighbor who no longer lives there on 3 Great Bay said, oh, I think your lot is my access to put in my boat. And we were picnicking, and he came down with his truck, with a big trailer on the back, with a fishing boat with an outboard motor on it. And my sister's co-owner of that. So her husband went over and said, you do not have the right to put your boat in on our land. And he started arguing with her. So we've had lots of issues, and we've tried to be very accommodating. A number of neighbors have said, gee, can I put my jet ski on your property because it's low enough where I could do so? Or when I take out my docks, can I use your property? Or when I want to walk to the neighbors, can I use your property? And we've let them do so. So in terms of overburdening the easement, I think it's important to realize that a lot of people over the years have used this property to enjoy the bog and the wildlife habitat. And I think leaving boats on the property, leaving lawn chairs on the property, putting up signs as if you own part of the property, putting tiki torches on your dock, it destroys some of the other neighbors' ability to enjoy this property the way it was intended. It was not intended to be a private beach area for the one resident who has a back lot. It's unfortunate, but that's the way it is. Actually, the beach area is very small. The fact that at high water there's no beach at all. The dock that was put in would not be adequate to tie a boat to. And we have bad storms. There's an area where it's a little peninsula, actually, land. And on the lake side, there's an area where it's exposed to a lot of wave action. The lake has been very high over the last 20 years or so, and it's already eroded in about 15 feet, let's say. We've lost 4 or 5 trees because of erosion from the lake coming in and from erosion on the stream coming in. So I think both the residents and the town have an obligation to protect the natural resource. It is within a floodplain. I have no idea why it was put on a map as a development district. You cannot build a house on it. It's literally tiny. There's only about 30 feet, 20, 30 feet maybe, not even that, between the edge of the land and the bog in the back. So I would just urge in consideration of whether you approve this document to think about the effect it might have on the wild bird habitat, on the marsh, on the water quality. We don't deny that everybody has the right to get there. And finally, I think the final point is, how can someone actually reach this area? The private driveway is, we've let everybody go down our private driveway. We don't have to do that, but we have. And it's about 170 feet of total of private driveway. Some of it now belongs to our next door neighbor, Tony Perfilio. And much of it belongs to us as well. And there's very little room between our house and the garage. The right-of-way actually goes about 4 feet from our kid's bedroom. And it goes to this woods, so that's why we let Holly Riccio's husband, instead of trying to traipse through this wooded area that you can see on that diagram, it's totally forested. It would have been very hard for her husband to walk through that area. And he certainly couldn't have taken a cart through that area. So we said, you can go down our driveway to get to that. And we totally respect people going down private driveways to reach this. However, if you start getting into maintaining bridges and docks and everything else, that starts to encompass trucks and equipment traveling up and down the private driveway right in front of our house in order to maintain it. So I think that's another issue. To summarize, we don't believe no one had, I want to read the quote from Joe Murray. So since neighbors said, we think we own part of this, I said, let me ask the tax assessor. Here's the quote from Joe. The assessment is nominal and is really just a placeholder to acknowledge there are deeded rights to the common area. The total assessment is $400, and by the current mill rate of $13.85 per 1,000 equals approximately $5 in tax. So yes, I guess each of our residents are paying about $5 in tax every year, just to simply have a placeholder to say you do have an easement that allows you to use this property in 3 specific ways: bathe, boat, or more boats. By the way, we're the one neighbor, since we are low, we do not have a dock. We've been there for 60 years now. I had a motorboat. We used to ski all the time. We swim, we boat, we take a canoe out to our moorings. So I would argue that a dock is not a necessity in order to bathe or moor boats. Thank you.
Can I ask you
Yes,
to read
yes.
the quote one more time from the tax assessor, please?
Yes.
Can you read the
So
quote?
I'll read it, yes.
Yeah.
The assessment is nominal and is really just a placeholder to acknowledge there are deeded rights to the common area. The total assessment is $400 and multiplied by the current mill rate, I'm not sure what the definition of mill is, but of $13.85 per 1,000 equals approximately $5 in tax.
Thank you.
Okay? Good, thank you.
Thank you, Mr. Piper.
Hi, folks. I'm Russell Taylor. I live on 14 Great Bay Road. I'd like to, I have the map, 1933, of the properties, and I'd like to, the JP and the, I'm sorry, I don't know your name.
Oh, Mac Walton.
Yeah, well, okay. I'd like a little clarification. If you could, gentlemen, could you find the common area on the map?
I'm assuming it's right here.
Correct. Could you look at lot number 11 and 12, please? Mr. Piper's area? Yeah, correct?
12 and 13, 11 is...
Oh, I'm sorry. Yeah. Can you tell me what it says, the amount of right-of-way? in feet?
You mean the width of the
Yes,
right
please.
way?
Yes.
Looks like it says 15 foot.
15-foot right-of-way. So we all have 15 feet of right-of-way to access our common area. Is that correct?
I mean, it looks that way from the,
It looks that way to me as well. And what's the date on the map, please?
August 1933.
Thank you. How many lots do you see?
13, 12 or 13, I'm not sure.
13?
Yeah.
Yeah.
13, I believe.
JP, can you tell me the number of frontage of the common area that's stated on the map, please?
The lakeside or
The lakeside, please.
192.
192 feet. Okay. There's a little river that flows through there. It's a seasonal river out of the bog. Do you see any bridge embankments?
Not a quick glance of it, no.
The two long,
I don't know what, they're not marked as anything, so
okay,
can't tell you what they are.
all right.
Tell if it's a, like, channel or what.
Yeah, those were the original bridge embankments for the bridge that used to go across there. So somebody asked the question of whether there was any building on the property, the common area, and it does show there, although it's not marked. You're correct, JP, but it does have some markings that show a bridge embankment. The other question is having a dock, and is that required for boating, swimming, or bathing, or mooring a boat? Can you imagine what it'd be like 4th of July weekend down at our town boat ramp without a dock? What would all mayhem look like with all these people in the water trying to get their boats in without a dock? What would that look like? Is that required? Why do we have a dock at our town ramp? If it's not required, we shouldn't have one. Obviously, we all know that would be total mayhem. People would be in the water, backing stuff in, trying to get their boats in. Of course you need a dock. I mean, it's just common sense. That's all I have to say. Thank you.
Other people from the public?
I didn't anticipate speaking tonight, but I heard Jeff talk about his mother. I'm sorry, I'm Dina Taylor, 14 Great Bay Road. He talked about his mother not being able to get down to the lake. Well, that will be me in a few years. I already have one total knee replacement. It's hard to scramble over rocks. If I have an easement where I can walk into the water or walk onto a dock, I think I'd really like that.
Doug Bonnicum, 12 Great Bay Road. I would just like to echo what Ms. Smith said, and I know we don't have the deeds in front of us of either property, but I lived in the bayou for 14 or 15 years between the two state parks at the other end of the lake. And we all had an easement to a property that we all enjoyed in our community and had docks on the space, and neighbors would actually share the docks. And I think without that dock that we had there, it would have not made us living there being possible or nearly as enjoyable. We're asking for not a system of docks, but many docks, but a single dock on this piece of property, which our interpretation of our deed gives us access to. I would echo what was just said about sort of our aging population. With all due respect to our audience here and to the board, we are all getting older. My wife has a series of friends who I think this year is probably their last year of being able to enjoy our boat, because unless we go down to the Standish boat launch, which is probably 10 miles away or so, they're not going to be able to get down our piece of property to access our boat, where we will be able to drive our boat over to this dock, single dock that we're requesting to allow people to ingress and egress off the boat. I would just like to echo what has been asked for, and again, further specify what Ms. Smet said is so important to everyone around the lake. And I know those aren't the only two properties that are able to enjoy this. Thank you.
Good evening. I'm Diane Piper, 36 Great Bay Road. Somebody asked the question, when did things change? And I'd like to clarify that things changed 4 years ago when Mrs. Riccio bought the property at 5 Great Bay Road. Please know that is the only lot in our development that does not have direct access to the water. That is when things changed, to answer your question. And I have to say that the common area, part of the reason we, the Pipers who are adjacent to it, are upset, it is not her personal waterfront, which is basically what it's become. I have to say, it's pretty interesting. I've been going to that property since I was 15 years old. I'm now 73. I have never seen one other person here come down and go through the lot for the purpose of bathing, boating, or mooring until 4 years ago when Mrs. Riccio moved in. People have come down to get blueberries. People have nicely asked, would you mind if we use your beach to do this or that? My husband said, yes, we've been accommodating. The neighbors laughed at that. I take great offense to that because we have been accommodating, and we have had things like ice shacks put on our property. We have had people, as he said, come down with a truck and interrupt a lovely family afternoon. They stood there and swore at us that it was their right to go in and use our beach. So yes, it was pretty upsetting 4 years ago when the realtor, which has nothing to do with Mrs. Riccio, but the realtor who represented that property had a picture of our beachfront on the ad, plus our private driveway, okay? We have the pictures to show you if you'd like to see that. Again, that common lot has never been used by any of these people up until the past 4 years because Mrs. Riccio does not have she does not have direct access to the water. She is welcome to come down and walk through the driveway, walk to that area. However, it is not her personal beachfront with signs, chairs, kayaks, a lot of paraphernalia. As my husband stated, our next door neighbor recently said, you know, that used to be a magical area. I can attest to his kids growing up, going over there fishing, my son putting a hammock there, reading Harry Potter to our granddaughter. None of that happens anymore because there's a dock, there's chairs, there's tiki torches, there's all kinds of paraphernalia. So I really do, I hope you will consider also what the tax implications. Yes, we pay taxes, $5 is the placeholder. So I hope you will uphold the attorney's idea that the dock should not be permitted for those reasons. Thank you very much.
Thank you. Others from the public?
Yeah, I think we're kind of getting lost in the weeds here a little bit. We just want to put the dock in. As far as the right-of-way that goes, it's actually common road. It's not actually an easement over anybody's property. This divides lots. They have a front lot, they have a back lot. That's how it reads on everybody's deed. Probably JP knows this. That subdivides front lots and back lots. So that's common, as is the common. So I just want to clarify that and just to reiterate that based on the law and the purpose of it indicated in our deed, we're just putting a dock in. And as far as some of the, Mrs. Riccio did not put the sign up. Neighbors in the neighborhood, when her husband died, thought it would be nice to put John's Landing up there because during their prior litigation, he never got a chance to use it. So, thank you.
Jeff,
Yeah.
I have a couple questions. One is, I just want to clarify, listening to the testimony from both sides, 15 property owners down there have rights to use the common lot as depicted in the deeds, correct?
Correct.
Of those 15, how many have waterfront properties on Sebago Lake?
14.
14. Of those 14, how many have docks?
13.
13. Okay. So are you suggesting that with this dock and this location, those 13 people will be using that for their boats?
Not right away, no.
Not right away?
No.
So you'll be abandoning your docks?
Excuse me?
You'll be abandoning your docks for the purpose of boating? Because you'll have this dock, right?
No, we're gonna keep our docks.
Okay.
Well,
So it's unlikely that you'll be using the common area for this dock, right?
correct,
Okay.
yeah.
I just want to clarify that.
There will be a time, in fact, if my mother actually comes to visit me, that I'll take her down and let her get on the boat there instead of going down to the marina.
Thank you.
And also, as far as the tax, being taxed on the property, I don't know that an amount really matters. If you're being taxed on something, then, to me, but again, regardless who owns it, that's more or less irrelevant. It's the fact that we have the purpose of bathing, mooring a boat, and boating. In order to boat, we're not boating on the common, we're boating in the lake. And in order to get to the lake, you need the dock to get to your boat. And in the definition, the dock is a platform used to secure a boat, access boat. It's nice and safe. You don't have to shuttle people out to the mooring in a kayak or a skiff. It's nice if you had a skiff, that would be great, but you would still want a place of that because you're not gonna be at 60 years old dragging a skiff up on the shore. So that's it.
Mr. Chairman,
Any other questions?
I ask a question.
Sure.
How do you get to your boat?
How do I get to my boat?
Yeah.
I have a kayak.
So you don't access your boat from your dock?
I bring my boat into the dock to have people get in and out, which makes it safe for everybody.
But you use a different watercraft to go out to your mooring?
Yes, to retrieve the boat, or I'll swim out to the boat. But when I do that, I'll come back, and whoever's going out, we don't all swim out. It just makes it safe for everybody.
Oh, absolutely.
Right?
Thank you.
Any other questions?
No, thank you. Well, any other questions for Jeff from the board? I do have a question. Thanks, Jeff. I do have a question for JP. Maybe you can, I'm curious about Mr. Taylor's comments about comparing this situation, at least in part, with the safety of a dock to the Standish Landing, which is public access to launch a boat, correct? But I also recognize there are, I don't know how many, could you clarify how many boats are in that lower basin on moorings,
I have no idea on the number.
approximately?
Are we talking the Standish boat launch, or we're talking?
Correct, the Standish boat launch.
I know there's more than 4 or 5. I honestly haven't been down there enough this year to see how many moorings are out there.
Actually, it's 6. It's some weird thing I actually counted the other day.
6.
For whatever reason, I was down there. There was 6 at the time, because I knew the season was getting late, and I actually saw 6 go, because they're on the shoreline, right?
Yeah, so I was down there earlier because I don't live on the lake, but I enjoy access to it, and I counted about 27 boats on moorings. This is several weeks ago. And I noticed that a lot of those boats had dinghies, or whatever you want to call them, up on the shore to access those moorings. So I get curious when we're using sort of words like chaos. If there was not a dock down there, it's common sense that you need a dock to access boats and this and that. I'm not sure that's really the case, because I think most of those people that actually use moorings down there don't use the launching dock, which is solely what it's designed to do, to access their boats. They use a smaller watercraft to go out there and tie off. I mean, that's the purpose of mooring. So I want to clarify that for the board based on what I see and what I'm aware of.
And 15, the use for 15 houses is not the same thing as the entire town of Standish?
That's correct. All right. Mike?
Another reason that Standish has a dock down there is that that area is in the 2-mile exclusion zone from the Portland Water Districts, where there is no body contact. So if they didn't have a dock, probably would be impossible for everybody to launch the boat without going somehow into the water.
Sure.
May I be recognized?
Sure.
Couple things. Earlier it got brought up, they had asked, was there ever a structure? Was it one of you guys that actually, on the Commons, was there ever a structure? Chris, you asked?
I asked if there had ever been a
So Russ
dock there.
reminded me, there certainly was, because there is a extremely large concrete footing there. So, you have a picture of that? No. So, on that frontage, it abuts the property from Sunnydale. I can't remember the gentleman's name, but that concrete structure is still there to this day. So it was put there. So there was a structure there. And it was pretty large, because if you look at this concrete footing, it's probably been there for 50 years. To address you can go out in your boat and get on your boat. If you've ever been in Sebago Lake and a storm comes across, we routinely get 3 to 4 footers rolling across. I need to get people off my boat. There is no way, no how that they are getting into a canoe or any kind of dinghy without risking their life. And Sebago's notorious for that. So the mere fact that we live in the lake and we have the option to moor our boat, the reason we moor our boats is because it's simply not safe to put them on the docks because of the nature of Sebago Lake. I'm fortunate enough I have a boat lift. But if you're not, I mean, before lifts, we've had times where you have to wait out in coves. There's no way you're getting people off your boat without a dock. I'm going to make my 91-year-old mother swim 100 feet? Well, of course I'm not going to do that. So it's just not, that's not reasonable saying you don't need a dock. It's in no way, shape, or form considering the size of this lake and what it's done. I have seen 4-footers. They destroyed our dock last year. Great Bay Road got wiped out. You're certainly not getting in a little paddle boat to get out of it as you're trying to outrun a thunderstorm. Thank you.
Can I agree about that? Just add information?
Sure.
Just yes, there is a remnant of 2 abutments. The one on the southeast end is still existing. Somehow the one on the northwest end was removed. But the Hayden family owned that property in the early 1900s. Harold Hanold, Herbert McClellan, and another investor, Albert O'Morian, bought the property from the Hayden family. It's often called Hayden Bog. So it was the Hayden family who had a cart path that went all along the shoreline, not on the beach, but inside the shoreline. And because they also owned way down, so they built a bridge so they could cross that property while they still owned it. As far as the earliest I went to the property was 1958. The second abutment was gone by 1958. There was no bridge there. Actually, the lake used to be much lower. Neighbors used to cross from Chapman Way to Great Bay because you could jump across the stream. And the level of the lake was usually where there was 20 or 30 feet of rocky beach before you reached the other part. At one point, our neighbor's son, Joe, I found out many years after it was done, well, they used to just put a 2x6 plank across the stream so people could cross. And all the people that crossed would walk across our property and up and down our driveway, and we never complained. So Tony Perfilio with his son Joe put a small little bridge so that we could walk across the bog. They were very good friends with with Maynard Jackson, who lived on Chapman Way, and they used to walk back and forth frequently. So that's why they built a small little bridge. They probably didn't have the right to do so, but they did so and no one complained. So that's just some background on that.
Okay. All right, anybody else? Any other questions from the board for anybody that has spoken this evening, that they'd like to revisit something or ask?
The quote from the tax assessor was quoted deeded rights. Can someone explain to me exactly what deeded rights means?
So there are multiple ways of obtaining the right to use land: adverse possession, a prescriptive easement. If you walk over someone's field for 30 years and they never complain, then you've established a right, but you don't have a deed to it. whereas a deeded right is they have a written deed that says they have the right to bathing, boating, and mooring boats. That's what deeded rights means.
So our tax assessor recognizes them as deeded rights.
Yeah, they're in the deed.
The rights, the right-of-way is in the deed, so that's not a dispute.
Okay.
But just because you have a right-of-way and your deed doesn't give you access to do what you want on that property either.
And it doesn't give you ownership of the property.
Yeah, I don't think anyone's disputing I don't think anyone's disputing they have access rights to that, to the common lot, and specific to the three things mentioned in their deeds. It's just how far do you want to interpret some of that language to extend to creation or installation of a physical dock? Do they have rights over that? That's the issue at hand. Any other questions for folks?
Just wanted, I mean, that Title 33, Section 459, pretty much states that under the definition of a dock, that in association with boating, securing your boat. So, again, that's a pretty strong link, I believe.
Well, you're right. However, I will quote, I'll read it. It says, it's focused on, it says, Section 459, easements and rights of way, installation of docks.
And easements,
And
correct.
and it says, a dock means a platform used for access to a water body or to secure, protect, and provide access to a boat or ship.
Correct.
The platform may extend from shore over the water body or may be a floating platform attached to a mooring.
So the mooring and the dock are separate.
Right. So it distinguishes a dock separate from a mooring, because what a mooring needs is an anchor. The dock can serve as an anchor, but that's, to me, it distinguishes them
All
separately.
I'm saying is a boat needs a dock. I mean, it's part of the use of
And,
boating.
and to the attorney's point, you'd be ultimately based on, the question of RTI, based on your deeds, you may be granted that, but that's for a court to decide. We don't have jurisdiction over that. We have jurisdiction over what the code enforcement officer has.
I don't think it's a giant leap to connect those.
The fact that we're having this conversation means that there's a dispute, right?
Right.
Were there no dispute, would there be an issue?
Probably not, right?
So because of one out of,
If there were no dispute, I don't think JP would even be aware of.
So let me,
dock
so
owner.
if I found out, so to answer your question, for me, if I found out that the dock was there on my own, went down, somebody boating, I go by there all the time on my boat. If I noticed the dock was there and I came back and there was no permit for it, then I would write up the violation for that. And then you'd have to apply for the permit, and then we'd look to see if you had a right title and interest, as we did.
correct.
And at that time, my opinion is that you don't have that in your deeds at this time, and that's why I gave the denial for that. And that's why we're here tonight. So yes, if there was no dispute and I found it or it got brought to my attention, then yes, there would be a dispute of what's going on.
Well, in Mr. Walton's letter, he stated the Rancourt versus Town of Glenbourne. That easement was just for ingress and egress. Ours is much more developed than that. I mean, we're boating, mooring, and bathing, so to me, it seems like a pretty strong connection. Thank you.
Okay. I'm going to close the public session. I'll make a motion to close the public session.
Second.
Any further discussion? All in favor? Any opposed? All right, so public session is closed. Thoughts, discussion from the board?
I put a lot of weight with Mr. Walton's letter because basically it says for bathing, boating, or mooring. I mean, then you can start adding all sorts of things that you want to add, but it's not part of it. Dock could be one thing. Then you can start adding lights and everything and electricity going down there. That's not stated in here either. So it's kind of vague as to for us to make a decision here. And I agree that this board does not have the knowledge or authority to make that decision.
And I tend to agree that some of this is interpreting what activities would be associated with boating, or what you could do to develop or enhance boating activities or structures, whatever. And we're not, I'm not an attorney that's here to define what the statute is designed to do here as it relates to a mooring interpretation versus a dock. But I do see them as distinct entities here. And I'm not, I think we all agree they have rights and access, as stated, to enjoy that property, as stated. The question is, do those rights go beyond that to construct things, such as a dock, or perhaps other things, based on their interpretation of what would benefit a mooring, would benefit boating? That's my concern. Other thoughts, or?
I see it as a seasonal dock. I don't see it as a construction. I see it as an enhancement to use it during a season, which I assume it's going to be taken out every year like every other dock on Sebago. And private or otherwise, if they own docks privately or not, they still have the right to use their right-of-way. And if they want a secondary dock on their right-of-way, good for them. They have the right-of-way to do it. They also have the right to have a private dock. Again, I live in an area that has this almost exact situation. 30 neighbors seem to do it just fine with one dock. We leave our boats neatly on the side of our right-of-way. We don't intrude on our neighbors. You have to be neighborly, not intrude on your neighbors, but I see it as these people are well within their rights to put a dock at the end of their common right-of-way.
Okay. Other thoughts or comments? Do folks feel we're prepared to vote? You guys good? Okay. I'll make a motion to uphold the code enforcement officer's determination from July 15th of 2024. The applicant has not demonstrated that their deeded rights to the common lot includes the right, title, and interest that would afford them the ability to install a seasonal dock.
Second.
It is seconded. Further discussion? All in favor? Opposed? One. Motion carries. Okay. Next steps would be to determine through legal means whether you have RTI for that specific common area. But we have voted to uphold the code enforcement officer's determination tonight. All right.
Thank you.
Any further items tonight to be for discussion? No? Okay.
Motion to adjourn.
Motion to adjourn. I'll second that.
Thank you, folks.
Thank you. Any further discussion?